Bail Amendment Bill, second reading.
The Honourable Minister. Anne Tolley.
Kia ora, Mr Speaker. I move that the Bail Amendment Bill be now read a second time. This bill makes changes that will improve public safety and ensure the overall integrity of New Zealand's bail system. In particular, the changes will make it harder for those accused of serious offences to get bail. We want to ensure that bail decisions strike the right balance between keeping the public safe and maintaining fundamental rights, such as the presumption of innocence and freedom from arbitrary detention. I'd like to commend the Law and Order Committee for its thorough consideration of the bill and for the sensible amendments it has proposed. The Government has adopted all of the proposed changes. The committee received 282 written submissions on the bill and heard 42 oral submissions. A number of the oral submissions were from victims of crime and their families. And on behalf of the Minister of Justice, I'd like to thank these people for their courage and their willingness to share their experiences to inform the committee in its consideration of the bill. I note that 119 submitters supported changes contained in the bill. Many submitters referenced the petition of Tracy Marceau on behalf of the Christie's Law Group and 58,000 others. Some proposals in the petition, such as those relating to judicial accountability, were outside the scope of this bill. They are being addressed by the Law and Order Committee separately. The bill contains two parts. Part 1 makes amendments to the Bail Act, while Part 2 makes amendments to other related legislation, including the Children, Young Persons and Their Families Act and the Sentencing Act. The changes contained in the bill fall into 6 broad categories. The first set reverses the burden of proof in certain cases to target defendants charged with the most serious offences and those with the highest risk of offending while on bail. A reverse burden of proof means that the defendant must prove that he or she should be granted bail. Under the bill, there will be a reverse burden of proof for defendants charged with murder. These defendants will need to satisfy the court that they will not commit any violent offences while on bail. Public safety will be the court's primary consideration in these cases. The bill also extends the list of very serious offences that currently carry a reverse burden of proof when the defendant has a previous conviction for one of these offences. Secondly, the bill improves the court's ability to deal with defendants facing serious drug charges. Defendants charged with Class A drug offences will now be subject to a reverse burden of proof when being considered for bail. And thirdly, the bill strengthens the ability of police and courts to deal with young defendants on bail. The bill retains the strong presumption in favour of bail for 17-year-olds who haven't previously been imprisoned. Those aged 17 who have previously been imprisoned and those aged 18 and 19 will be subject to the standard adult test for bail. The bill also gives police new powers to deal with defendants under 17 years of age who repeatedly breach their bail conditions. The fourth set of important changes contained in the bill relate to police bail. This is bail granted by police before the defendant appears in court for the first time. The bill increases the penalty for failing to answer bail in these circumstances to 3 months imprisonment, in addition to the existing maximum fine of up to $1,000. The bill abolishes monetary bonds and sureties for defendants on police bail. These bonds and sureties are not available in the district court. They were seldom, if ever, used by police because they are very difficult to enforce. The fifth group of provisions relate to electronically monitored or EM bail. Currently, EM bail is granted by the courts under their generic power to impose bail conditions. The government believes, however, that there should be specific provision for EM bail in the legislation to ensure that it is applied consistently and effectively. The bill formalises the current arrangements whereby defendants can only apply for EM bail after they have been remanded in custody. The statutory regime will ensure a consistent process for assessing the suitability of defendants for EM bail and monitoring them in the community. The final set of provisions promotes the integrity and operational effectiveness of the bail system. These amendments will reduce situations where a defendant will be bailable as of right and restore the jurisdiction of justices of the peace and community magistrates to deal with certain defendants who breach bail. Finally, the committee has recommended a number of minor and technical amendments to the Bail Act. These recommendations follow on from the recent reforms made by this government under the Criminal Procedure Act and ensure consistency with recent changes to criminal procedure. Mr. Speaker, this government recognises that a person charged with a crime has the right to be considered innocent until proven guilty and the right not to be arbitrarily detained. However, these rights must be balanced against the safety of the public. The government is committed to bail laws that make New Zealand a safer place and keep victims at the heart of our criminal justice system, and this bill demonstrates this commitment. The New Zealand public deserves bail laws that protect them. The Minister will be tabling an SOP which will clarify the drafting and technical amendments required to bring the bill in line with the recent changes to criminal procedure. The SOP will also propose changes to the management of the electronic monitoring regime so that corrections staff may undertake assessments for EM bail as well as police. I believe that the amendments recommended by the committee respond appropriately to issues raised in submissions, and once again, on behalf of the Minister, I thank the committee members for the work that they have done on this bill. Mr. Speaker, I commend this bill to the House.
Thank you. The question is that the motion be agreed to.
Mr. Speaker.
I call the Honourable Philip Goff.